Okay, ready to proceed?
Your Honors, good afternoon. Gustavo Bruckner. I'm joined by my colleague Emily Kamlosi. We represent plaintiff appellant Ms. Shiva Stein, and I would like to reserve 3 minutes for rebuttal if I may. Your Honor, Ms. Stein submits that the trial court misapplied the exception to the appraisal statute as set out under Williams v. Stanford, and furthermore did not draw all reasonable inferences in favor of plaintiff as it must on a motion to dismiss. Just like Williams, this case is about breach of fiduciary duties, breaches of fiduciary duties of a majority buyer engaged in improper self-dealing to eliminate the ownership stake of minority stockholders. In this case,
Here's the problem I'm having with that, just to focus in on that. In Williams v. Stanford, what we had was a small corporation where there was specific self-dealing that was done by one of the persons in the corporation. And it seems to me that here you've got general complaints about a situation involving, self-dealing and sort of the way the deal was structured, okay? That seems to me to be very different than Williams v. Stanford, and it's really closer to sort of what we contemplated in our decision of foreclosure-free search. So the question really is if you've got facts like you've alleged here, why isn't the best method to resolve those issues the accounting? In other words, this isn't a fraud case where you've alleged the fraud that, that was at issue in the First District case, Stanford case.
Let me be clear, Your Honor, that Williams wasn't about fraud, because if it was purely about fraud, they wouldn't have to do the whole analysis of how to interpret the statute. The statute is very clear. The exception to the statute in 4B says fraud or misrepresentation. Williams went to look to see how Delaware dealt with fraud and misrepresentation because it had self-dealing and other...
But you did have fraud, and it did involve fraud factually. And then when we decided foreclosure-free search, we said, we were discussing Williams, we said, where the acts of waste of the corporate assets make the valuation of the appraisal date unfair, a minority shareholder alleges specific acts of fraud, misrepresentation, self-dealing, or deliberate waste of corporate assets may be entitled to equitable remedies beyond an appraisal if the alleged acts have so besmirched the propriety of the challenged transaction that no appraisal could fairly compensate the aggrieved minority shareholder. So if the allegations make it appear that an appraisal could fairly compensate the minority shareholder because there's an absence of Stanford fraud, why isn't that remedy the appropriate remedy in this case?
A couple of factors. First of all, I think foreclosure-free search reinforces that there, in fact, is additional remedies besides appraisal when there are these other things besides fraud. And in foreclosure-free search, they had not pled, they hadn't come to that determination of whether all these other things occurred, which we've pled here. 9 out of 29 pages of our complaint is about the unfair process and the misrepresentations. But the other thing I would say, Your Honor, is appraisal is a remedy for a particular, we have other things here that infected the process, that made it not as the language was, besmirched the proprietary of the, I'm sorry, I'm blanking on the language, but the point is, appraisal would value the company at one point in time just before consummation. And what we have here is allegations of a controlling stockholder who with the target, have valuable assets. In the complaint, we set out how they talk about just before the acquisition in the December press release and announcing the earnings in the March 2016 release, they talk about how blue-green, the core asset, is poised for growth. But stockholders don't have any information about blue-green. They do, they have it. There weren't any appraisals conducted on the underlying real estate assets for several years. So this is an ongoing process. So appraisal wouldn't be fair. Also, the coercive nature of the transaction, where they have this majority of the minority and we don't know who's in the majority or excluded from that because of the language in the proxy. And also, you've got this blow provision that they put in, that if 150,000 shares of stock seek appraisal, the buyer can walk away. And then after the fact, they then go and try and self-exculpate themselves. So I think you've got certainly unfair dealing here that maybe it does rise to fraud, I don't know, but.
Well, I looked at the trial court decision, and a major basis for his decision was that the complaint, as he read it, wasn't giving any specific acts of fraud, misrepresentation, self-dealing, or deliberate waste of corporate assets. So then I look at your appeal and saying, they must put in these specific, if that were me, I'd say, okay, here's from our complaint, the specific. It seems a lot of them are more omissions, that they didn't disclose this, but as opposed to that they falsely disclosed. So are you arguing that not giving enough information opens up that avenue to get equitable remedies beyond appraisal? And do you have any cases that support that? I wrote down like 5 different things, and I kept on saying, where's the fraud? False, incorrect, or omitted evident information. I guess that would be fraud, but that was just a vague comment.
Again, Your Honor, it doesn't have to rise to the level of fraud. It's just information that's missing, so a stockholder can't even make an informed decision. You have here a valuation analysis performed by the banker for the target that says, well, this stock is valued at either $9 range or 43 to 52 and change. You could drive a truck through that. If my kid came home with temperature of 94 or temperature of 104, that's a symptom something's underlying is wrong, and I would call the doctor right away.
It may be sloppy, but then there's a remedy. It's like, okay, we'll get an expert in here to give an independent appraisal. So, but it seems that the statute's saying to go outside of that, you need, as Judge Gross said in Williams, sort of a smoking gun, something overtly that sort of, they deliberately did it so that you couldn't really, even with a new appraisal, you wouldn't be able to. Are you saying that they deliberately omitted information?
I'm saying, Your Honor, it doesn't matter if they did or didn't. It's not, fraud is not, if it were just fraud, we wouldn't have to do the Williams analysis because the statute's pretty straightforward.
Well,
it says fraud or misrepresentation.
Deliberate waste of corporate assets.
And Williams follows Delaware precedent that says fraud or misrepresentation also includes unfair dealing. And that's what we have here. And I think we've laid out.
Where do you allege that the appraisal would have been inadequate? You allege, you've said a couple times that the minority shareholder wouldn't have the necessary information, but where do you allege that triggering the appraisal right, that appraisal wouldn't have been adequate?
Again, Your Honor, the stockholder didn't have enough information to know whether or not to seek appraisal. And then there's this coercive nature that if they do decide to seek appraisal and somehow 150,000 shares of stock also seek appraisal, the buyer walks away. What if this was the best price ever? What if this was a terrific price? Stockholder would lose that opportunity by the fear of seeking appraisal and then causing the buyer to walk away. That's also an issue. That goes to the coercive nature of the transaction.
Did Stein have 150,000 shares? I mean, is that?
She did not have 150,000 shares, Your Honor, but she couldn't communicate with every single other stockholder, and she doesn't know what the other stockholders are planning to do or not. I'd like to reserve the rest of my time for rebuttal.
Let me ask you a quick question.
Sure.
If we affirm, what happens to her BBX shares? Does she get $20? Does she get the 5.4, or does she just walk away with pretty pieces of paper?
That's a good question, Your Honor. There are a number of remedies that I suppose are available. We could rescind the transaction, or we could have a post-closing.
I'm saying if we affirm. If we.
Oh, I'm sorry. Oh, I hope you
affirm.
don't. If you affirm, I guess that she's done. And she.
Took a stand and.
She'll have her whatever number of shares or.
She still gets the shares, or the shares are in a company that's no longer, right?
They get stock cash
With
or stock.
BBX.
Yeah.
She doesn't-
In
BBX is
BFC,
gone.
she'll get the
Oh,
equivalent in
she
BFC.
does get B, so she's
Yes.
still,
Or cash. Every stockholder who,
so there's no total loss here.
but she,
Either gets equitable remedies if we reverse, or she gets the benefit of the original bargain.
she gets either every stockholder, minority stockholder, got either cash or stock in BFC.
But didn't they have to act within a certain period of time?
They had to act within a certain time, and I don't know what the default was. Defendants perhaps could
Okay.
tell us. Thank you.
Okay, thank you, Mr. Bruckner. So you've got 3 minutes on rebuttal.
May it please the court, Gene Stearns, on behalf of BFC and its directors, let me start with answering the last question. The default provision here was if a majority of the unaffiliated shareholders voted yes, which they did, and a shareholder did not elect between stock and cash, the shareholder was automatically given cash at $20 a share. That represented a premium against the market of 27%. Alternatively, had a shareholder elected stock, which most did, the shares would have been 5.4 shares for every 1 share of BBX. And the appraisal documents, which has been characterized here as reflecting a value between $14 and $50 or $60, misrepresents, in fact, what the disclosure is. What the investment bankers did was to do 3 different analyses. One was because this is a public company where the shares are traded publicly, they analyzed the history of the trading and did a valuation based on how the market perceived both companies. And they came up with a value of somewhere in the ballpark of $15 a share. Then they did a second analysis showing book value, and they came up with a value that was approximately $20 a share. And then they did a third analysis, which they called a sum of the parts, where they did it for both the buyer and the seller company, and they concluded that the exchange ratio that would be fair on that basis would be approximately 4 shares to 1. So what the company did was to offer 5.4 shares to 1. This was not a cash-out merger. This was not a transaction which has been characterized here as the shareholders being given a ticket to the road, goodbye. In fact, based on the allegations of this odd complaint, a shareholder who elected stock received an enormous benefit because if the company's assets were worth as they might have been and might be, then in fact the ratio of 5.4 shares to 1 gave the acquired company's shareholders a substantial benefit. In fact, 98%, as the record reflects, of the unaffiliated shareholders voted in favor of the transaction of those who voted. If you exclude those who didn't choose to vote, it was over 70% of the non-affiliated shareholders voted yes. And of the people, whether they voted or didn't vote, those who chose stock were predominated. And
Okay,
therefore,
I'm sorry to cut you off, but, okay, so the trial court ruled on the motion, granted the motion to dismiss, which is a high standard. But he did so saying he didn't see in their complaint any allegations to bring this to out beyond the appraisal. Am I right in assuming that they're not arguing fraud or misrepresentation necessarily? They're saying unfair dealing.
well, their argument, first of all, if you go back to Williams or you look at foreclosure-free search, the standard is different than that. And now, let me quote, because I think it's important, the language is important. Where the committed acts, quote, have so besmirched the propriety of the challenged transaction that no appraisal could fairly compensate the grieved minority shareholder. That's the standard in Florida. And keep in mind, we can talk about Delaware cases, but Delaware does not have what Florida has, which the Florida legislature adopted, which is exclusivity of this appraisal process with a very narrow out, which Delaware does not have. You get into Delaware cases only if you first escape the Florida statute. And what Williams held, and this court adopted that standard in foreclosure free search, is have so besmirched the propriety of the challenge transaction that the appraisal the day before the announcement could not give the shareholder a fair price. There's no allegation of that here. In Williams, for example, you had, according to that court, years of misappropriation of corporate assets so that the company had been looted. So if you look at an evaluation the day before a merger, the money was gone. And so how could an appraisal statute give you fairness? In foreclosure free search, you had an issue as to whether or not the person who was the shareholder actually owned the stock. And what counsel completely omits is the fact this court overruled and reversed an injunction against the appraisal process. Because this court in foreclosure free search said, in the appraisal process, you get discovery, you get to find out what the assets are worth, but the bizarre nature of this claim is, while the word fraud and inside dealing is all alleged, there's no there. What is the argument? They say that the proxy said the shares might be worth $50 a share. Well, that's in the proxy. And it talks about the exchange ratio. So if they believe, so there's nothing concealed. What they want is to take discovery to find out if what the proxy said was true when they allege that it's true, but if it's in the proxy, how can they claim fraud? And so what this court said in foreclosure free search is the appraisal process gives them that opportunity to take discovery. But what you can't do in corporate transactions in Florida is create this environment where every merger ends up with a lawsuit. And the lawsuit does nothing but parrot what's in the proxy, put the label of it as fraud, and then say, pay me and I go away. That's what's going on here. And so what you're left with is a claim that they can't even conjure up an argument. And Judge Forrest, the same questions you ask about fraud, the trial court asked. Where's the fraud here? And when, by the way, they say they wanted leave to amend. But under 1.190, you're supposed to file an amended pleading and say, what are you going to say different? And what did they do? They said, Judge, give me another chance. But they didn't say what they would allege if they were given another chance. And the judge says there's nothing here other than you have failed to allege that the day before the appraisal process, the stock wasn't worth what you could establish it would be worth in an appraisal proceeding. So what you're left with here, Your Honors, is a claim that is simply meritless, and the judgment should be affirmed. And frankly, this is important for Florida law, Florida corporations, where you need certainty in these kinds of transactions, and that certainty was achieved here.
So are you saying that Stein needed to allege elements of common law fraud, or?
You had to allege that even if it's not just common law fraud, it's beyond that. It has to be so pervasive that the appraisal doesn't give you an adequate remedy. That's what's missing here, is that what they're alleging is the price is too low. But in fact, they were given three choices. $20 a share, which was a 27% premium to the market, 5.4 shares to 1, which meant they could stay in the company if that's what they wanted and get the benefit of the great asset they claim is so valuable, or alternatively an appraisal. They were given those three choices. And now what they have, they want a fourth choice, which is, okay, we want our cake, we want to eat it too, and now we want to litigate a class action involving something not based upon any argument that the company wasn't worth or couldn't be established what it was worth the day before the merger, but because they claim that because these companies, which by the way were always related, had the same offices, the same officers, they were public companies separate only because of banking laws. When Bank Atlantic was owned by BBX, it was a holding company, and so you ended up with this structure. But BFC owned collectively 81% of BBX. 19% of the equity was publicly owned in 16 million shares, 13 million of which were owned by BFC. The 3 million that weren't owned by BFC were asked, and by the way, the company didn't have to give the minority a veto over this, but chose to. The company said, we're not going to do this and let a majority of the minority vote yes, which they did.
If the appraisal comes out and says $20 wasn't a good price, 18 was a better price.
That's the law.
So then she's stuck with 18?
Indeed, that occasionally happens, Your Honor.
Okay, and if they say 22, then
Then the
she,
company pays 22.
and whether it's 22 or 18 determines who pays for the appraiser, or?
Well, it's a judicial process. The way it works is they first have to vote no, then they have to submit their shares and demand appraisal rights. The company, and they have to make a company then has to make an offer to buy the shares. Then they can respond to that offer, and if they can't agree at that point, the company is required by law to file a lawsuit to establish an appraisal process. And in that lawsuit, the value of the shares are determined, and it could be anything. But the point is, in this instance, whether she owned 1 share or 10 shares or 100 shares, whatever it is, clearly 98% of the people who were same position she was in voted yes in favor of this transaction and wanted it to proceed. And the company, by deferring to the minority shareholders, in fact, gave them the veto power over a transaction. And in fact, once they, and there's no argument that what was disclosed was wrong or incorrect. They merely want to take discovery to see if what was disclosed is correct. That's not the basis of a fraud claim.
Are there any other Florida cases where a motion to dismiss was granted?
Your Honor, the answer is there's very little case on the subject generally. You see that in Delaware now, where these cases are being disposed of on motions to dismiss. But most importantly, you address the allegations, because the allegations are accepted as true. But for the allegations to meet a standard to establish a claim, those allegations have to establish one. And where here there's no allegation of fraud, what was there to do? I mean, what more was there to do if the plaintiff can't allege fraud, and given the opportunities who says, I want to amend, but can't allege any facts that would support a claim for fraud, dismissal was the appropriate remedy.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Stearns.
Good afternoon. I'm Brian Miller. May it please the court, from Ackerman on behalf of the independent members of the special committee. I'd like to just have 3 minutes to address the alternate ground of dismissal, if that's all right with the court.
Okay, 3 minutes. I'm going to strictly limit you to 3 minutes.
All right. Thank you. So I want to address the alternate ground, which was the Delaware case law called Kahn versus M&F Worldwide, or MFW, that the court relied on to dismiss the complaint.
Has this court addressed Kahn? Was that brought up in foreclosure-free form?
No, Your Honor, it was not.
Okay.
This is the first instance where this court is presented with whether to adopt that standard. And as far as I'm aware, none of the other DCAs in Florida have yet addressed the issue either. The trial court was absolutely right to dismiss the complaint based on that Delaware standard. The record and the proxy statement lays out the extensive process that these special committee members went through. It's at pages 1148 to 1155 of the record, which goes over their 6 meetings they had over a course of 3 months. They hired independent counsel in my firm. We did not represent BFC. They hired an independent financial analyst to advise them on the transaction, and they deliberated and they went through an entire process that's laid out in the record. Also at page 1155 of the record, their independence is set forth. They were completely separate and unaffiliated with BFC. They were directors of BBX Capital, the other company, and that's why they were appointed to the special committee. Now, the trial court properly adopted the MFW standard, just like New York courts have done. The New York Court of Appeals also adopted that standard. The plaintiffs don't dispute that it's a proper standard to apply to a merger such as this, where there's an affiliated party buying out the minority, and this court should adopt the standard too. It's important to note that the idea and the standard of MFW is to dismiss claims. That's precisely what the Delaware Supreme Court did in the MFW case. They said no longer is it necessary to spend millions of dollars on defense costs and lawyers' fees and years to litigate something to determine whether it was a good deal. If you satisfy the 6 factors of this test, it will be appropriate to dismiss the complaint. The New York Court of Appeals in the Kenneth Cole court case also said the same thing. It's a dismissal standard. Subsequent case law, for example, the Books A Million case that we cited in our papers in Delaware, have dismissed complaints based on this standard.
So if we find that we can't do one of the 6, are you saying, all right, go back to the other grounds?
Well, first of all, that's right, Your Honor. This is an alternate ground. Excuse me. We certainly believe the trial court was right on the exclusivity of appraisal, and that's a sufficient ground to affirm the ruling. Excuse me. I suppose that if the court disagreed and reached the other ground, then yes, it's the case you have to establish each of the 6 factors. And we laid out in our papers how they're all established. I don't want to go through them all. I will just point out that it's in the record on the majority, the minority, the first standard, that pages 1265 and 1356 of the record lay out the math so that you can see that the affiliates were not included in that calculation that arrived at a 70% approval. And I also want to say that with respect to the power to say no, the special committee did have the power to say no to BFC because they did say no. The very first offer was at 1675 and a 365 ratio. The committee said no to that, negotiated for a much higher price. So I'd say on that factor that the plaintiffs attacked, the proof is in the pudding that they did have the power to say no and did do it. So for all the reasons outlined in our papers, and as I've mentioned, the alternate ground of dismissal was appropriate and the trial court should be affirmed in all respects.
Okay,
Thank you.
Thank you, Mr. Miller.
Your Honors, I want to clean up a few things here. Let me point out that MFW, the Kahn case, and Williams were both on summary judgment, not at motion to dismiss stage. There was extensive discovery in both actions. Mr. Miller just said that the special committee had the power to say no because they said no to the price. There's a difference between negotiating a price and saying no to the deal, and that's not what happened. Remember that this is a situation where 3 times in the last 5-6 years, they tried to cash out the minority stockholders. By the way, at each time, it was for the exact same price. It was always $20 and 5.4 shares, actually 5.39 at one time. But there was no movement whatsoever. And when the special committee agreed to a price, a couple of weeks later, the buyer, BFC, said, you know what, we're underpaying you. We're going to sua sponte increase the price here because this is not a fair price. I also want to point out, Your Honors, I heard Mr. Stearns talk about the majority of the non-affiliated stockholders supporting this transaction. We don't know if that's true because we don't know, by virtue of the definition in the proxy, who's included. It says that BBX affiliates BBX should not be counted as an affiliate of BFC, and BFC should not be counted as an affiliate of BBX. And it says BFC affiliates will not be counted in the vote. It doesn't make sense. One other thing I want to point out, in an appraisal, I believe there's no jury trial in appraisal. That's also a significant difference. And if there's nothing to see here, if nothing's going on here, and we're not alleging fraud, this is not what this case is about, but why did they self-indemnify themselves? What was the point of that? And that's certainly something we would put in an amended complaint. And then there were also some additional stock transfers that occurred after the fact that was in SEC filings. But, Your Honor, it's all the more important in a controlling stockholder situation that the directors be candid and must fully disclose all information that's important to the stockholders to make an informed decision. I know Florida courts have not ruled on what the appropriate standard is on the duty of disclosure in this kind of situation. The United States Supreme Court in the TSC opinion, which was adopted by the Delaware Supreme Court, says that if the information for a reasonable investor were to alter the total mix of information available, then it would be material. And here we have pages of information that we believe is material, which I refer you back to the briefs. Your Honors, unless you have any questions for me, I respectfully request that you reverse the decision of the trial court and allow this case to proceed to the merits.
Okay, thank you, Mr. Partner.
Thank you.